Hello friends, in the series on the income tax cases, today we will discuss a case which is based on a situation that when some upward adjustments are proposed by transfer pricing officer and the draft assessment order is sent to the assessee based on that recommendations of the transfer pricing officer, and when assessee files the objections before the DRP and the jurisdictional assessing officer passes the order without following the directions of the dispute resolution panel, then in that case, what is the fate of that assessment order? This issue has been taken by Delhi ITAT bench in the case of Comparex India Private Limited versus Income Tax Officer, and this case is reported in 115 ITR short notes 19, and the date of the judgment is 9th September 2024. The facts of the present case are like this. In the present case, the assessing officer referred the matter to the transfer pricing officer under section 92 CA subsection 1 to the transfer pricing officer. The transfer pricing officer suggested some upward adjustment in regard to intra-group services, backward support services, payment of sourcing fees, etc. When these upward adjustments were proposed by transfer pricing officer, then on the basis of these upward adjustments, the jurisdictional assessing officer made a draft assessment order and sent to the assessee. The assessee was not convinced with these upward adjustments, so the assessee filed the objections before the dispute resolution panel. After hearing the assessee, the dispute resolution panel sustained the upward adjustment in regard to the intra-group services, but deleted the upward adjustments in regard to the back support services and payment of sourcing fees, etc. When these suggestions were given by the DRP, the transfer pricing officer accordingly altered his order, but when the jurisdictional assessing officer passed the final assessment order, he didn't follow the directions of the transfer pricing officer and the dispute resolution panel. The assessee went to the tribunal against this final assessment order. The plea before the tribunal by the assessee was that the assessment order has been passed without following the directions of the DRP, hence it is not a valid order in the eyes of the law. And the main contention of the revenue was that it was a mistake on the part of the assessing officer. So practically they were praying for the remand back of the matter. But when the tribunal heard the matter, the tribunal was of the considered view that if it was a mistake on the part of the revenue, then the assessing officer should have rectified this order under section 154. Since the assessing officer did not take any steps to pass the rectification order and pass the assessment order without following the directions of the TPO and DRP, so in this case, the assessing officer has grossly violated the provisions of the law. The tribunal further said that the final assessment order passed by the learned assessing officer is final for all the purposes, including the payment of the taxes, and the tribunal quashed the assessment order passed by the jurisdictional assessing officer. So friends, from the crux of this case, it is very clear that the jurisdictional assessing officer is bound to follow the directions of the DRP, because the directions of the DRP are from the higher authorities, so they are binding on the assessing officer and he should consider those directions. At the end of this deliberation, once again I am repeating the name of the case. The name of the case is Comparex India Private Limited versus Income Tax Officer, and this case is reported in 115 ITR Tribunal Short Notes 19, and the date of the judgment is 9th September 2024. Thank you, friends.